Hello everyone, welcome back to my channel, and this is the continuation on our discussion regarding law and obligations and contracts. As you all know, we have different classifications of obligations, and the primary classification of obligations under our civil code are the following. We have pure and conditional obligations, which is under Articles 1179 to 1192, obligations with a period, alternative and facultative obligations, joint and solidary obligations, divisible and indivisible obligations, and obligations with a penal clause. But for this video, guys, we will be discussing a pure and conditional obligation under Articles 1179 to Article 1190. Let me check. 1191. Okay. 1192 pala. Sinama ko pala yung 1192 dito. So, that's 1179 to 1192. Okay? So, let's start. So, Article 1179 refers or gives us the definition of what a pure obligation is, and it is immediately demandable regardless of the presence of a condition or a term or period. So it is not subject to any condition, and no specific date is mentioned for its fulfillment, and of course, therefore immediately demandable. So what could be an example of a pure obligation? Let's say, for example, debtor obliges himself to pay creditor the amount of 10,000 pesos. So in this obligation, it is immediately demandable because there is no condition and no date is mentioned for its fulfillment. On the other hand, we have here the definition of a conditional obligation, which states that it is one whose consequences are subject in one way or another to the fulfillment of a condition. So let us first define what is a condition. So a condition is a future and uncertain event, the happening of which the effectivity or extinguishment of an obligation or right subject to it depends. Okay? So now, what are the characteristics of a condition? It is a future and uncertain event. Okay, so in order to constitute an event as a condition, it is not enough that it be future. It must also be uncertain. So hindi mo alam whether or not the event will happen. Okay? Past but unknown. The second characteristic, a condition may refer to a past event unknown to the parties. So if it refers to a future event, both its very occurrence and the time of such occurrence must be uncertain. Otherwise, it is not considered as a condition. And take note, a condition must not be impossible. Okay? Okay. Now, for the next is the obligation with a period, which is covered under Article 1180, which is defined as a period is a future and certain event upon the arrival of which the obligation subject to it either arises or extinguishes. Okay? So actually, we will be discussing the different kinds of condition after this slide, but let me first enumerate when an obligation is demandable at once. So we have here when obligation is demandable at once. First, when it is pure, okay? And this is the definition of a pure obligation. Second, when it is subject to a resolutory condition. Or third, when it is subject to a resolutory period. Take note, condition, future and uncertain event, period, a future and certain event. Okay? So, now, under Article... Okay, before we proceed, we will be discussing first the different classification of conditions. Okay? What are the different classification of conditions? We have here, as to effect, we have suspensive condition, the happening of which will give rise to an obligation. Resolutory, meaning the happening of which extinguishes the obligation. As to form, we have to express or implied. When we say express, the condition is clearly stated, or implied, the condition is merely inferred. How about as a possibility? We have possible, condition, the condition is capable of fulfillment legally and physically, or impossible, which means the condition is not capable of fulfillment either legally and physically. As to cause or origin, we have three: potestative, mixed, or casual. When we say potestative, the condition depends upon the will of one of the contracting parties. Mixed, if it depends partly upon chance and partly upon the will of a third person. Or casual, wherein it depends upon chance or upon the will of a third person. As to mode, we have positive or negative. When we say positive condition, it consists in the performance of an act. When we say negative, it consists in the omission of an act. As to numbers, we have here conjunctive and disjunctive. When we say conjunctive, it refers to several conditions. It has several conditions, and all must be fulfilled. And disjunctive, when several conditions and only one or some of them must be fulfilled. As to divisibility, it could be either divisible or indivisible, wherein divisible condition are those susceptible of partial performance, while indivisible condition refers to those that are not susceptible of partial performance. Okay, so it's a little bit overwhelming, but take note that we will be discussing it one by one. So the two or primary kinds of condition is here. We have the suspensive and the resolutory. Okay, so now let's proceed. So kindly familiarize yourself with the different terms used or different classification of conditions, because we will also be having this, in the next slide. Okay, so the principal kinds of condition based on or classified according to their effect, we have suspensive condition and resolutory condition. The concept of suspensive condition is that the fulfillment of which will give rise to an obligation, while under resolutory condition, the fulfillment of which will extinguish the obligation. So now, when we say it will give rise to an obligation, so let's have an example. P, a testator, in his last will and testament, gave some property to his heir provided he will die within 2 years. Okay? In this case, his heir would acquire a right to the land only upon the happening of the suspensive condition. The suspensive condition in that example is the death of the testator within 2 years. So, of course, if there is no length of time within which the death must take place, the obligation is one with the period. If they died after 2 years, the situation would be the same as if no provision was made by T in his will in favor of his heir. Diba? So, if namatay daw si T, okay, within 2 years, so, ibibigay niya daw yung mga property niya kay heir. Pero of course, pag hindi, it is as if the condition did not exist. Okay? When we see resolutory condition, let's have an example. X binds himself to support Y until Y graduates from college. Here, the right is already acquired by Y. That is the right to receive support. So, meron na. Ngayon, meron ng support. So, pag nangyari yun, pag graduate na siya, okay, the condition there is when Y graduates from college, therefore, the obligation of X will be extinguished or lost once the condition is fulfilled. Okay, so that's the two. The suspensive condition, remember, the fulfillment of which will give rise to an obligation. On the other hand, resolutory condition, the fulfillment of which will extinguish the obligation. Suspensive condition, wala ka pang kinakailangang ibigay, wala ka pang kinakailangang gawin unless the condition will happen. Okay? Sa resolutory, you need to perform, you need to give na until the condition is fulfilled and your obligation will be extinguished. Okay? Now, Article 1181 gives us the effect of happening of the event. So, it reiterates the distinction between a suspensive condition and a resolutory condition. So, under the suspensive condition, there is an acquisition of rights by the creditor. Depends upon the happening of the event which constitutes the condition. On the other hand, under resolutory condition, the happening of the event which constitutes the condition produces the extinguishment or loss of rights already acquired. Okay? I hope that is clear. Now let's move on to Article 1182 that discusses about the potassive condition. So a potassive condition is a condition suspensive in nature in which depends upon the sole will of one of the contracting parties. Now, take note, but if it will depend upon the sole will of the debtor, so si debtor daw yung may say. Okay? Pag sasabihin ni debtor, I will pay you if I want. So sabi ng batas, conditional obligation is void. Okay? Bakit? The conditional obligation is void because its validity and compliance is left to the will of the debtor. What if the debtor will not pay? Diba? Walang willingness. So what if the condition is, I will pay you after I recover what X owes. Okay? So may utang si X sa kanya, babayaran kita kung babayaran kanya, okay? If babayaran siya ni X. So nagdi-depend lang siya sa will of the debtor. So sabi, the conditional obligation is void. However, take note, if the obligation is pre-existing one and therefore does not depend for its existence upon the fulfillment by the debtor of the potassive condition, only the condition is void, leaving unaffected the obligation itself. Here, the condition is imposed not on the birth of the obligation but on its fulfillment. Okay? So, for example, the debtor borrowed 10,000 from the creditor payable within 2 months. Subsequently, the debtor promised to pay the creditor after the debtor sells his car after the debtor sells his car to which the creditor agreed. So in this case, only the condition is void but not the pre-existing obligation of the debtor to pay C. Okay? So may pre-existing obligation na siya, so valid naman yon. Yung condition lang na subject to which depends upon the sole will of the debtor is considered as void. Now, on the other hand, okay, if it will depend upon the sole will of the creditor, of course, the obligation is valid. Kasi nga naman, normally, the creditor is interested in the fulfillment. Gusto niyang mag-fulfill yung obligation because it is for his benefit and it is up to him whether to enforce his right or not. Okay? Now, what about if the obligation is resolutory in nature? The obligation is valid although its fulfillment depends upon the sole will of the debtor. Kasi nga, under the resolutory condition, meron na siyang kinakailangang i-fulfill ngayon. And that the debtor is naturally interested in its fulfillment. And the position of the debtor when the condition is resolutory is exactly the same as that of the creditor when the condition is suspensive. Okay? Once yung condition na fulfill na, wala nang obligation si debtor, kaya valid siya if the obligation is resolutory in nature. Okay? And it depends upon the sole will of the debtor. So, yan. Now, let's move to impossible condition under 1183. So, Article 1183 states that impossible conditions, those contrary to good customs or public policy and those prohibited by law shall annul the obligation which depends upon them. If the obligation is divisible, that part thereof which is not affected by the impossible or unlawful condition shall be valid. The condition not to do an impossible thing shall be considered as not having been agreed upon. So when does Article 1183 applies? Okay? It applies only to cases where the impossibility already existed at the time the obligation was constituted. If the impossibility arises after the creation of the obligation, Article 1266 of the Civil Code or the new Civil Code governs. So what are the different kinds of impossible condition? We have physically impossible condition. Those are impossible, okay, physically impossible condition, legally impossible condition. When we say physically impossible condition, when they in nature of things cannot exist or cannot be done. Hindi talaga maaari. Okay, so let's say for example, I will pay you 10,000 if it will not rain for 1 year in Iligan. Okay, that's physically impossible. Diba? Even before, history tells us wala talagang isang taon na hindi umulan. So that's physically impossible condition. Now, on the other hand, what about legally impossible condition? Let's say, for example, X will give you 1 million pesos if you will slap his father. Okay? That is considered legally impossible condition because that is against good customs. Okay? Or how about if you will publicly advocate the overthrow of the government. So that's legally impossible because that is against public order. Now, what is the effect of these impossible conditions? Impossible conditions annul the obligation. Thus, conditional obligation is void. Okay? Impossible conditions annul the obligation. So, parang wala. Okay, that's conditional obligation. However, if the condition is not to do an impossible thing, it is rendered pure and valid. Kasi nga, in obligation not to do, okay, parang wala kang kinakailangang gawin na imposible. Kasi nga naman, hindi naman magagawa yung imposible, guys. Okay? Now, if the obligations is divisible, the part thereof not affected by the impossible condition shall be valid. So, kunin natin yung mga hindi valid na condition. Okay? Only the affected obligation is void. Okay? So, let's say for example, I will give you 10,000 if you sell my land and a car, okay, if you will slap your father's face. O, diba? Yung if you will slap your father's face, that is what? It is what? It is invalid because it's impossible, legally impossible kasi against good custom yun. So, yun, the obligation to give the 10,000 is valid. Okay? But, the obligation to give something is void because it is dependent upon a legally impossible condition. Now, if the obligation is a pre-existing obligation, only the condition is void. Kasi nga, merong obligation, there is already an existing valid obligation, yung condition lang naman, yung parang nadagdag lang naman yung impossible condition dun. So, yung condition lang is void. Okay? Now, let's proceed with Article 1184. We have here positive condition. So, positive condition, the happening of an event at a determinate time. Okay. The obligation is extinguished as soon as the time expires without the event taking place, or as soon as it has become indivisible that the event will not take place although the time specified has not expired. Okay, what could be an example of a positive condition? Sabi niya, positive condition, the happening of an event at a determinate time. So, example, you obliges yourself to let's say for example, A, 10,000 if A will marry, let's say for example, si B, si A at saka si B. So, bibigyan mo daw si A ng 10,000 if pakakasalan niya si B before B reaches the age of 25. Okay? So, you will be liable to A if they will get married before he reaches the age of 25. However, he will not be liable if they will marry at the age of 23 or at 25 or after he reaches the age of 25. Okay? So, happening of an event, the obligation is distinguished as soon as the time expires without the event taking place. Okay? Yung condition mo dapat, ganun, bibigyan kita ng pera kung pinakasalan mo before. Di ba? May ganun-ganon. So, once the time expire, okay, dumating na yung araw na naging 25 na sila, pero walang nangyari. So, your obligation is distinguished. Or, let's say, for example, as soon as it become indivisible that the event will not take place, although the time specified, hindi nga ababot ng 25, hindi pa 25 years old yung dalawa, but one of them got married to another individual. Okay, so that is an example of a positive condition. Effect, take note, obligation is distinguished. Okay? Next up, we have, so meron tayong positive condition under Article 1184. We also have a negative condition under Article 1185. That an event will not happen. So ito, happening of an event at determinate time. Ito naman, event will not happen at a determinate time. The obligation shall become effective and binding from the moment the time indicated has elapsed without the event taking place, or from the moment it has become evident that the event cannot occur although the time indicated has not yet elapsed. Okay? Yung isa, dapat maganap muna yung pangyayari. Okay? Mag-i-extinguish ko, may ganon-ganon. Same. They are similar in the sense na yung may dapat pangyayari, like the condition will happen. So, let's say, for example, ito naman, baliktad din natin. Yung isa, kinakailangan makasal sila. In the negative condition, hindi sila makasal. Okay? So, if they will not get married by the age of 25. So, it will be effective and binding from the moment the time indicated without the event. Nag-lapse lang. Okay? Will not happen. So, he will not be liable. Okay? He will not be liable if, for example, they will not get married. Okay? Pero liable siya if, for example, okay, so you will be liable if on that particular date, they are not yet married, okay, and if they will marry another person after that particular date indicated. So, klaruhin muna natin, okay? Summarize na natin, okay? So, for example, X binds himself to give B 10,000 if B is not yet married to C on December 30. Okay? Hindi pa sila kasal on December 30. So, take note, X will not be liable to B if B marries another person on December 30 or prior thereto. Okay? But X will be liable to B if on December 30, B is not married to C, and if B marries C after December 30. In the latter case, the condition, which is not marrying, is fulfilled upon the expiration of the time indicated, which is December 30. Okay, so that's Article 1185. So, 1185. So, meron na tayong mga condition na na-discuss. We have suspensive condition, resolutory condition, impossible condition, positive condition, and negative condition. So, what's next? Under Article 1186, constructive, it talks about constructive fulfillment. 1186 is a very short provision. It states that the condition shall be deemed fulfilled when the obligor voluntarily prevents its fulfillment. So what are the requisites? The condition is suspensive and that the obligor actually prevents the fulfillment of the condition and he acts voluntarily. Take note, the law does not require that the obligor acts with malice or fraud as long as his purpose is to prevent the fulfillment of the condition. He should not be allowed to profit from his own fault or bad faith. Okay, so what would be the effect? Condition is deemed fulfilled. This article also applies to an obligation subject to a resolutory condition with respect to the debtor who is bound to return what he has received upon the fulfillment of the condition. Okay. That is 1186. Now let's proceed with Article 1187, which talks about the retroactive effects of fulfillment of suspensive condition. According to the article, it will retroact to the day when the obligation is constituted. How about the fruits and interest? So, if under reciprocal obligation, there is no retroactivity. Okay, bakit there is no retroactivity? This rule is necessary for purposes of convenience, since the parties would not have to render mutual accounting of what they have received. Fruits here, take note, may be natural, industrial, or civil fruits. How about in unilateral obligation? There is usually no retroactive effect because they are gratuitous. The debtor receives nothing from the creditor. Those fruits and interest belong to the debtor unless from the nature and other circumstances of the obligation, it should be inferred that the intention of the person constituting the same was different. Okay, so that's Article 1187. Now, okay, Article 1188, the rights pending. It talks about the rights pending the fulfillment of a suspensive condition. We have here the rights of the creditor. The creditor may take or bring appropriate actions for the preservation of his right, as the debtor may render nugatory the obligation upon the happening of the condition. On the other hand, the debtor is entitled to recover what he has paid by mistake prior to the happening of the suspensive condition. This is a case of solutio in debiti, which is based on the principle that no one shall enrich himself at the expense of another. 1189. Article 1189 is applicable only if the obligation is a real obligation, the object is a specific or determinate thing. Oo nga naman, kasi nga, pag generic thing yan, hindi to applicable kasi nga, generic thing, genus non comperate, okay? Then, the obligation is subject to suspensive conditions, the condition is fulfilled, and if there is loss, deterioration, or improvement of the thing during dependency of the condition. So, what are the rules under Article 1189? So we have here rules on loss of the thing. If there is loss of the thing, deterioration and improvement without the fault of the debtor or with the fault of the debtor. Take note, loss of the thing. Loss in civil law may be physical loss, that is when a thing perishes, as when a house is burned and reduced to ashes. It could also be a legal loss, when a thing goes out of commerce, or when a thing heretofore legal becomes illegal, or civil loss when a thing disappears in such a way that its existence is unknown. Say, for example, a particular dog has been missing for some time. Okay? So, what are the rules? If the loss of the thing is without the fault of the debtor, the obligation is extinguished. But if the loss of the thing is due to the fault of the debtor, he will be liable for damages. Okay? Now, deterioration. Deterioration of the thing. Deterioration of the thing through deterioration muna when its value is reduced or impaired. If it deteriorates without the fault of the debtor, impairment is borne by the creditor. But if it deteriorates with the fault of the debtor, the creditor can choose between rescission plus damages or fulfillment plus damages. Okay? In either case. So, damages in either case. Now, for improvement when its value is increased or enhanced by nature or by time. So, if the improvement is without expenses, yung parang walang ginawa si debtor, wala, nag-improve lang talaga siya, the improvement shall inure to the benefit of the creditor. But if it is with his fault, nag-improve siya because meron siyang ginawa at his expense, he shall have no other right than that granted to the usufructuary. Take note, usufruct is the right to enjoy the use and fruits of the thing belonging to another. The rights granted to a usufructuary are that he may make on the property held in usufruct such useful improvements or expenses for mere pleasure as he may deem proper, provided that it does not alter its form or substance. He could set off the improvements he may have made on the property against any damages to the same naman. Okay, so that's Article 1189. Mahaba-haba siya, pero ginawa na lang natin siya ng table para mas easier. Okay, so now, under 1190, the effects of fulfillment of a resolutory condition. So, konti na lang, malapit na tayong matapos, malapit tayo sa 1192, guys. Konting tiis na lang. So, now, effects of fulfillment of resolutory condition in obligations to give. Obligations is extinguished and the parties are obliged to return to each other what they have received under the obligation. And in obligations to do or not to do, the court shall determine the retroactive effect of the fulfillment of the resolutory condition. Okay. Now, okay, natatandaan niyo naman yun, di ba? The resolutory condition, the fulfillment of the resolutory condition will extinguish the obligation. Article 1191, the obligation according to the person obliged, you have unilateral or bilateral. Unilateral, when only one party is obliged to comply with the prestation. Bilateral, when both parties are mutually bound to each other. And in bilateral, it could be a reciprocal obligation, those which arise from the same cause and in which each party is a debtor and creditor of each other. So let's say, for example, in a contract of sale, in the absence of any stipulation, the delivery of the thing sold by the seller is conditioned upon the simultaneous payment of the purchase price by the buyer. So reciprocal, bibigyan mo siya ng pera, of course, bibigyan ka din niya ng something. Okay? The seller is the creditor as to the price and the debtor as the thing, while the buyer is the creditor as to the thing and debtor as the price. On the other hand, we also have non-reciprocal obligations, or those which do not impose simultaneous and correlative performance on both parties. So let's say, for example, X borrowed from Y 5,000, Y on the other hand borrowed X car. Okay, the performance by X of his obligation to Y is not conditioned upon the performance by Y of his obligation, vice versa. The obligation of X arises from the contract of loan, while that of Y from the contract of comodatum. So they are non-reciprocal obligation. Now, what are then the remedies? In reciprocal obligations, okay, action for specific performance of the obligation or action for rescission of the obligation. In either case, with payment of damages. Okay? So, yan. In case, remedies, choice of remedies. Yan. In case one of the obligors does not comply with what is incumbent upon him, the aggrieved party may choose between the two. Okay? Okay. Now, let's proceed. Limitations on right to demand rescission. So, we have limitation. The right to rescind by the injured party or the one who has performed what is incumbent upon him is not absolute. Thus, rescission contemplated by this article is a judicial rescission, or one granted by court. The injured party has to resort to the courts to assert his rights judicially, for the same article provides that the court shall decree the rescission claim unless there be just cause authorizing the fixing of a period. So, of course, no person can take justice or the law in his own hands and decide by himself what are his rights in the matter. The other party must be given an opportunity to be heard. Okay? Second, limitation on right to demand rescission, that the court has discretionary power to allow a period within which a person in default may be permitted to perform his obligation if there is a just cause, for giving time to the debtor as where the default incurred was not willful or could be excused in view of the surrounding circumstances. Next limitation is on the right of the third person. If the same subject matter of the obligation is in the hands of the third person who acted in good faith, rescission is not available as a remedy. Okay. Next, on the substantial violation. The general rule is that rescission will not be granted for slight breaches of contract. Okay. The violation should be substantial as to defeat the object of the parties in making the agreement. Thus, in a case, it was held that delays on 4 occasions in the payment of rentals for a few days were not substantial violations in a contract of lease to justify rescission, because the law is not concerned with trifles. And finally, on waiver of right, the right to rescind may be waived. expressly or impliedly. Thus, the acceptance by the seller of the land sold as security for the balance of the price is an implied waiver of the right to rescind in case for non-payment by the buyer. So, his remedy is to recover the balance. So, those were limitations on right to demand rescission. But wait, there's still more. How about rescission without previous judicial decree? Where automatic rescission expressly stipulated, so the parties may validly enter into an agreement that violation of the terms of the contract would cause cancellation thereof even without judicial intervention or permission. Okay? So, next, where the contract is still executory, so when there is no performance yet by both parties, but one is ready and willing to comply with what is incumbent upon him and the other is not, the willing party may, by his own declaration, rescind the contract without a previous judicial decree of rescission. Take note, in such a case, it is not necessary that there be stipulation providing for automatic rescission. And lastly, in this video, so pinakalas na talaga guys, under Article 1192, this Article 1192 states that in case both parties has committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. Yan. Where both parties are guilty of the breach, if first infractor is known, the liability of the first infractor should be equitably reduced. And the second one, if the first infractor cannot be determined, the contract shall be extinguished and each shall bear his own damages. Okay. In effect, the court shall not provide remedy to either of the parties who must suffer the damages allegedly sustained by them. Okay. Yeah. So that would be all for this video, guys. And please let me know if you want to suggest anything to make these videos good and like, yung magagamit talaga ng mga estudyante, and it will be helpful in order for this to be a very good video. So susunod ng mga video, I'm open to suggestion, guys. You can just put a comment below this video, and hopefully you will be subscribing to my channel. Thank you and good night. Bye.